everyone. I'm Judge Jackie Powell, and this is First Appearance Court. Today, I'll let you know if I've determined probable cause from the police reports I read this morning, and then we will talk about release conditions. Today is not your trial date. It's not an adversarial hearing, and so because of that, I encourage you to speak with your attorney if you have one before speaking on the record. Everything in this courtroom is being recorded and can be used against you at a later time. For those of you who are represented by the Public Defender's Office, you need to know that in the courtroom with me, I do have one of the attorneys from the Public Defender's Office, Mr. Brian Reedy. Over at the main jail, there is another attorney over there, Mr. Hector Romero. These attorneys are also available to those persons who are at the other three facilities. Those of you who are represented by private counsel, the attorneys normally come to the courtroom and are able to address your case from here. If your attorney's not in the courtroom, you can let me know. If you have the phone number or the name, I will try and reach that attorney. However, I ask you, please don't tell me that you have private counsel if you or your family did not retain them for this recent arrest. Just because an attorney represented you in the past or maybe is representing you on a pending matter does not automatically mean that they're representing you on every single case that you will ever have. And so unless you or your family have spoken to the attorney, chances are that they are not representing you. In the courtroom with me, I also have the attorney from the State Attorney's Office, Mr. Eric Linder. And I also have representatives from confinement status, pretrial supervision, the clerk of courts, and all these persons are here to help with the morning's hearing, and they can provide additional information if needed. After today, your case will be assigned to a specific division judge, and then moving forward, all your pretrial motions, if you end up going to trial, those will be heard by that division judge. Some of you may see me again for 30-day motions or for second looks at your bond status, but for the most part, everything else that will happen with you will happen in your division. Some of you charged with misdemeanors or municipal ordinance matters today may be able to resolve your case here at first appearance, but that's also going to be dependent on what's going on with you personally. Those of you who are facing felony matters, violation of probations where the judge has already signed a warrant and issued a no bond hold, those cannot be changed at first appearance. You must see your division judge to address those issues. All right? Do we have anyone that they've asked to call out of turn?
Not that I've been advised of, Your Honor.
Okay,
There's two people.
okay.
First individual will be on page 16 of the docket. His name is Mr. John Lattimore. And the second individual will be on page 17, Mr. Fernando Beckford.
All right, let's address John Lattimore. All right, Mr. Lattimore is before the court this morning. Charge 1, carjacking with a firearm or weapon. Number 2, use or display a firearm during a felony. Number 3, carrying a concealed firearm. Number 4, grand theft of a firearm. Number 5, resisting officer without violence. And number 6, under 18 years of age, unlawfully possessing a firearm. Yes,
Actually, charge 2,
yes.
I know what it says for the actual charge. It's actually attempted robbery with a firearm. It has that in the comments section of the booking.
Okay, so just for clarification, number 2 is attempted robbery with a deadly weapon. I find probable cause for all these charges.
State would be seeking a no bond hold on count 1 upon finding a proof evident or presumption grade for first appearance purposes. and ask that he be held no bond so that he can have an Arthur hearing in front of his assigned judge, Judge Merrigan.
We would be objecting to that, Judge. The state is just relying on an affidavit that's provided by an officer who did not witness the events themselves. Proof evident presumption grade is the highest burden of proof that we have in the criminal justice system. The state has produced no witnesses, they've introduced no evidence, so our position is that they have not met that very high standard. We would ask the court to set bond for Mr. Lattimore, or in the alternative, if over our objection, the court does find that proof evident presumption grade has been established, we would urge the court to exercise its discretion and set bond for Mr. Lattimore in this matter.
All right, this court, having reviewed the warrant to arrest and the affidavit, that has been, that was attached, and noting that this incident was captured on surveillance video at the Walgreens where this occurred, and also the fact that the victim did ID this Mr. Lattimore, I am going to make a preliminary finding of proof evident presumption grade as to charge number 1 at this time. Mr. Lattimore will be held no bond. This is without prejudice for him to have a bond hearing versed on State v. Author before his division judge.
Your Honor, as far as count 2, if I may, I'd be recommending a $50,000 bond. I'm showing an arrest in Dade County from October 30th of this year.
What's the nature of that arrest?
I'm showing that it is, what do you want, Florida summary? Robbery with a firearm.
So this court will note that this is after the date of this incident, which was October 11th.
And just to note, Your Honor, it gives the offense date.
October 9th, I'm
No,
sorry.
it gives, and for the Dade County arrest, it gives an offense date of July 28th, 2019, just because I want to put on the record that they involve different.
Okay. Mr. Romero?
Judge, he's 17 years old, he's not working, no property, no money in the bank, he's financially indigent.
All right. This court also notes that there's already been an order signed to direct file Mr. Lattimore, so even though he's 17, he's been charged as, he's been filed as an adult. And taking that into consideration, and the fact that there is another incident this year of similar nature, I am going to impose on the charge number 2 a $50,000 bond, and then the other standard bonds will remain in place. Okay? All right, Fernando Beckford.
Judge, he's
On
approaching.
page
At this time,
17.
we're going to be waiving the formal reading of the chart.
Okay. All right, the defense has asked that the waive formal reading of the charge, and so I find probable cause this morning.
And Your Honor, I have Detective Wilfredo Rivera is present in court
Okay.
to provide additional testimony.
Okay. Detective, please raise your right hand. Do you swear or affirm to tell the truth?
Yes,
Okay, and please state your name for the record.
Wilfredo Rivera,
All right, state.
Detective Rivera, who are you employed by and in what capacity?
I'm employed by the Broward Sheriff's Office and Special Victims Unit Detective.
And how long have you been a detective with BSA?
About 6 years.
And you conducted an investigation into Fernando Beckford that led to his arrest on November 12th of this year?
Yes,
Okay, and this arrest, and you authored a probable cause affidavit in conjunction with this arrest?
yes,
And you're familiar with the contents of the probable cause affidavit you authored?
Yes.
The listed victim in the case, whose initials are JM, could you please tell the court the victim's age?
His current age is 11.
And are you familiar offhand with his date of birth?
I'm not. It's October 2008. I don't remember the exact date. 2008?
Are you familiar with the the section of your probable cause affidavit where you mentioned that Mr. Beckford, provided a post Miranda statement?
Yes.
And you mentioned that Mr. Beckford advised that his wife provided him with the allegations against him.
Yes.
Did he advise you what those specific allegations were?
Yes.
The nature of those allegations?
Yes.
And could you please explain to the court what, if anything, caused you concern about him making that statement?
Well, there were a couple concerns. One, those are not the allegations that are mentioned in this incident at all. And two, she didn't even know what the allegations were herself.
So just to clarify, what he claims the allegations were made against him, that his wife advised him, those were not the allegations that the victim and his brother mentioned to you in their statements?
No.
And he advised his wife told him what the allegations were?
Yes.
And you had an opportunity to speak to his wife?
Yes.
What did she advise you that she knew about the allegations?
All she mentioned was some sort of abuse.
So
She wasn't sure if they were physical or sexual in nature.
I have nothing further, Your Honor. Your Honor, at this time, the state is going to be seeking a finding of proof evident or presumption great. Excuse me. For first appearance purposes only, and ask that Mr. Beckford be held no bond. Sworn statements are taken from the victim and his brother that were consistent in nature, detailing the alleged abuse, Your Honor. I would note, as far as statements that Mr. Beckford made that I believe are incriminating in nature, one specifically that he mentioned in his statement that when asked if it was possible that these allegations could have occurred and he didn't remember, he stated yes. Your Honor, I believe, and I would point to Isaza v. State, which the same exact allegations were made where the defendant in that case stated he could have had any, and he might not remember. And I believe that is so incriminating, Your Honor. We're not talking about whether someone forgot to lock the door or whether somebody left the stove on by accident. These are allegations of such an aggravating and violent nature, frankly, of a sexually violent nature, Your Honor. I can't imagine how it could be possible that someone could commit these acts and forget that they occurred. Additionally, Your Honor, he made inconsistent statements to law enforcement, stating that his wife told him what the allegations were with specificity, when it turns out she didn't even know specifically what the allegations were. Why would he misrepresent that to law enforcement? And then he is claiming that he knew what the allegations were, and they're not even the same allegations that the children made. Your Honor, I believe in totality that there is proof evident or presumption great that Mr. Beckford committed this offense against the listed victim.
And we would object. It doesn't even appear as though anybody really knows what happened here, Judge. We have all kinds of conflicting statements all over the place. So based on that alone, I don't think that there's proof evident presumption great, and I don't think there's reason to hold Mr. Beckford without bond at this point. And again, proof evident presumption great is the highest standard of proof that we have. It's beyond a reasonable doubt. It's a higher standard than beyond a reasonable doubt, and I certainly haven't heard anything here, either from the detective or from reading this probable cause affidavit, that would rise to that level. So I think bond should be set for Mr. Beckford. There's talk about all these statements and everything else, recorded statements of the victims. Those haven't been played for the court. There's a statement made by Mr. Beckford. That hasn't been played for the court. It certainly wouldn't take much effort to bring a tape recorder in here and let the court hear that to make a determination as to whether or not the state has met the highest burden of proof that we have in the criminal justice system. Instead, they've just brought the detective in to say, hey, here's what I here's my recollection of what happened. Certainly the detective didn't witness any of these events taking place. So based on all of that, Judge, I would ask that this court not make a finding of proof evident presumption great, set bond for Mr. Beckford, or if, over our objection, the court does make a finding of proof evident presumption great, set a bond for Mr. Beckford using your discretion.
I'm sorry. I was just going to say, Your Honor, just because Mr. Reedy says there's inconsistencies doesn't make it so. Reviewing the statements given by the victim and his brother, they're consistent with each other. There is no inconsistencies between the allegations as to what occurred. And, Your Honor, and I know we bring this up all the time, but I'm just making an argument for the record, and I'm not even going to mention Isaza. The Fourth DCA is very clear in bracket, and this is the exact language. The state may properly rely upon affidavits. And Mr. Reedy's aware of this case law from the Fourth DCA. He's essentially arguing that we are improperly relying upon an affidavit by saying we should have to provide more.
No, the Fourth District Court of Appeals never said what Mr. Lender said they said. They said the court can rely. It doesn't say the court has to rely on it. Whether or not the state wishes to introduce certain evidence in a hearing in which they are held to the highest standard of proof that we have is up to them. Mr. Lender says, hey, there were no inconsistencies between the statements of the two brothers. Well, let's hear these statements. Let's find out if that's the case.
Well, I'm gonna stop you, because this is first appearance, a probable cause finding, and I know that this is a proof evident presumption great, but this is not beyond a reasonable doubt. This is not trial. And if there are whatever inconsistencies that you believe or that the defense believes, then there'll be another time for that to be raised. What I have before me this morning is that there's a family who adopted children, and then that these children are now alleged victims of sex crimes by persons who adopted them. And in the police report, there is no conflicting statement about what the children told the officers. That's what I have. The story is the same, and then based on other statements from the defendant before me this morning. And so based on everything that I've heard this morning, I am going to make a preliminary finding of proof evident presumption great. And Mr. Beckford will be held no bond until further order of the court. I'm also ordering no victim contact, and that means no phone calls, no text messages, no social media, no third-party contact with the minor children.
Your Honor, just for clarification, your no contact order includes JM and CG?
Yes.
Thank you, Your Honor.
Okay. All right, thank you.
Judge, our interpreter is here.
Yes. Who needs the Spanish interpreter?
On page 19, Mr. Domingo, I think.
Page 19, Mr. Domingo. Señor Domingo.
Okay.
All right. Madam Interpreter, if you'll raise your right hand, do you swear or affirm to translate from Spanish to English and English to Spanish?
I do to the best of my abilities, Alicia Stegmore.
All right, thank you, Ms. Stegmore. Mr. Domingo, you are before the court this morning for an ad charge. It's an immigration hold.
Señor Domingo, usted está aquí para un cargo agregado, es una detención de inmigración.
And this is a no bond hold, sir.
Y esta es una detención sin fianza, señor.
And so you will have to appear before an immigration judge on this matter.
Así que tiene que aparecer frente al juez de inmigración en este asunto.
All right. Is there someone else who needs a Spanish interpreter?
Not here at Maine, Judge.
Okay.
None that I've been advised of, Your
All
Honor.
right, thank you.
Thank you, Your Honor.
Thank you. All right, Natalie Baxlaw.
She's approaching, Judge, she's here, man. Come on
Oh,
up, Ms. Baxter.
Mr. Shade, I didn't see you over there. All right, Ms. Baxlaw, you're before the court on one charge of touch or strike battery. I find probable cause.
Judge, I did speak to Ms. Baxter earlier today. I did advise her of the standard bond, which is currently in place. Unfortunately, she advised me financially she's not going to be able to post that bond, nor anyone's going to be able to post that bond on her behalf. Now, my understanding, Judge, she's working right now. She's working for a construction company, which basically sends her on different types of jobs, where she's been doing that now for about 5.5 years.
Does Ms. Baxlaw have any priors?
Yes, Judge. Her history.
My understanding, yes, she does, Judge, but she also told me it's been a couple of years since she had her last contact.
Could you check? Could you check her? Okay. Your Honor, I only have Broward, but her history: 2012 possession of cocaine, fleeing and eluding. 2012 possession of cocaine. 2009 possession of cocaine, a year and a day. 08 possession of cocaine. 05 possession of cocaine, battery, prostitution. 03 resisting without violence. 03 cocaine. Goes on from there, Judge.
All right, I noticed that Ms. Baxlaw has several AKAs, none of them with the last name Baxlaw. They're all Crumbly or Camp. Crumbly spelled different ways.
I
Anemic.
believe Crumb's her maiden name.
And Baxlaw is my married name.
But I would also note Diane is definitely not her first name, from what I can tell.
Yes,
There's
it-
an AKA of Diane Nemec.
All right,
But just like I said,
based on the allegation, she has a $1,000 bond.
Judge,
right,
would you sign
Counselor.
a photo order Judge, can you sign a photo order?
Yes.
Thank you, Judge. And a photographic order.
Okay.
Both. Thank you, Judge.
And, Your Honor, it would appear they know each other, so I'd just ask.
No victim contact, Ms. Baxlaw. No victim contact. That means no phone calls, no text messages, no social media, no third-party contact. Do you understand that?
Yes, ma'am.
All right. On page 14, I have a Sydney Glick.
Good morning, Your Honor. I'm Stella from Erie Hospital's office on behalf of Mr. Blake.
Good morning, Mr. Stella.
Good morning, ma'am.
All right, is Mr. Glick in the room? Sydney Glick?
Yes, he's approaching. There's your private counsel, sir. Come on up.
All right, Mr. Glick is before the court. Charges 1 and 2 are trafficking in oxycodone, less than 100 grams, and I find probable cause for both of those.
Judge, in addressing the issue of bond,
Yes,
Mr. Glick is an 84-year-old man with a cadre of illnesses that include insulin-dependent diabetic. He's lost, as a result of that, he's lost the sight in one of his eyes and the other one is going. He has kidney issues, etc. The defendant, we have known for some time through his family. We're here at no cost to him as a favor to his family. Mr. Glick has very limited means, and candidly, I think the court will find that these two buys or these two allegations of sale were to supplement his rather meager Social Security income. That doesn't excuse his behavior, but nonetheless, we were made aware of these warrants and we voluntarily, or Mr. Glick, I should say, voluntarily surrendered himself. I can't imagine a better candidate for pretrial release, and I'm just asking the court, in light of the fact that you found probable cause, to allow the defendant out on pretrial release.
Your Honor, I can advise the court. I spoke with Assistant State Attorney Tom Hand this morning. He's on our drug trafficking unit. He filed the charges. It's going to be his case. And we're both, we're very aware of a lot of the information that Mr. Stella provided you. We specifically discussed this case this morning. We don't have an objection to his release to pretrial.
Thank you, Mr. Linder.
Well, if it's acceptable to the court, obviously. But, Your Honor, may we approach?
so you know. Is it something that you want off the record? Because there's nothing. Okay.
standard bonds are nowhere near $700 million for these.
Exactly.
I always want to be frank with it, or our conversation, my conversation with Mr. Anthony, we're not asset for anything.
So based on the representations by the parties, I will agree to a pretrial, but it is going to be a level 2 pretrial supervision. It will be on an anchor monitor, and and those, and whatever limitations come with the level 2, okay?
Very good, Your Honor, and thank you.
All right.
Thank you, Mr. Linder.
I'm sorry? What do you want? Right.
All right, Mr. Shade. On page 2, Anna Donis.
Okay. Judge, this is actually a City of Hollywood case. It says Dania Beach on the docket. It's a time-served offer.
All right, Ms. Donis, you're before the court on a capias for a prostitution charge, and this capias was issued October 10th. Would you say the City of Hollywood?
It is.
City of Hollywood is offering you time served if you wish to resolve your case. Do you wish to accept that at this time?
Yes, ma'am.
All right, please raise your right hand.
I said at least.
Yes, ma'am.
Do you swear or affirm to tell the truth?
Yes, ma'am.
All right, you can put your hand down. And do you understand the offer that has been extended to you?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorney?
No, ma'am.
You understand that you have the right to go to trial, but by taking a plea today, you are giving up that right.
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
In the past, ma'am.
And is there anything about that treatment that today would prevent you from making a decision?
None whatsoever, ma'am.
And do you understand that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
Yes, ma'am.
What plea do you wish to enter at this time, guilty or no contest?
No contest, ma'am.
All right, I accept your no contest plea. I find that it's freely and voluntarily given, your sentence, adjudication, and time served.
Thank you, ma'am.
You're welcome. David Beanie on page 4.
Chairman. Good morning, Your Honor.
Good morning, Mr. Beanie. You have 2 charges this morning. One is a municipal ordinance violation. One is a state charge for possession of drug paraphernalia. The municipal ordinance violation is for sleeping on the beach. I find probable cause. All right.
Judge, they're actually both city cases.
Both
City-
of them?
City counts, correct.
They're both city cases.
Oh, okay.
So they're both city municipal, that's your attorney right now.
No, count,
No,
count.
you sure?
State charge.
One,
sure?
the drug, the
paraphernalia is
drug
under the state
paraphernalia is a
statute.
state.
Oh, it is, okay, I'm
Yes.
sorry.
Yeah, so it is. One's a municipal and one's a
Sorry
state.
about that, Judge.
All right, so what does Mr. Beanie want to do today?
Judge, for
Judge,
the,
it's been Mr. Beanie. He's looking forward to having his day in court. However, as you can see, the bond that's in place right now, he cannot afford. He's homeless. However, he did advise me as a mailing address, so he'll make sure that he gets court notices to make sure to come back to court so he has no sort of case issues. Now, he has prior contact with the criminal justice system, but from what he told me, it's been about 4 years clean. He's been here his whole life. He's 55 years old. Right now, he's looking for work. He was previously working for a roofing company, but now, unfortunately, he's no longer working there. Now he's looking for work. So we're asking on this non-violent offense, if the court will consider releasing him, one RWR or the other.
Does the city of Hollywood have programs for housing?
This is Fort Lauderdale, Judge.
Oh, so
So,
which, oh,
this,
oh, this is Fort Lauderdale.
you see any, I mean,
So-
he might be eligible for the.
So is he eligible for a community court, and is he interested in that?
Let me ask him that.
What would,
He could only do the community court though, Judge, on the city case, not the state case.
if he's been qualified as career offender?
No, I think he can, the state case can go as well. There's some
Okay.
state charges that can go, yes.
Okay.
He's previously gone to.
And Judge, he would be interested in that. In
Yeah.
seeking
He's a
service.
what?
He has a, oh, he has crimes of violence?
eligible
No,
for
then he's not eligible, no.
No, I don't have anybody, Brian. No,
Assault,
not now, but.
not now, in the past. They're saying that he's gone to prison for, what is the charge?
Aggravated assault with a deadly weapon, 2011 case.
Okay. All right, so what is the, is there an offer?
I mean,
Doesn't matter if it's long ago, sir. If you have a prior in the past, it's a prior in the past. You can't say you don't have a prior. There's something in the past. And, when you read these probable cause affidavits, sometimes you see how things can be so avoided. The officer goes to him and say, you can't be sleeping on the beach. He tells him, I can sleep on the beach because it's a public park. That's what the probable cause affidavit says. And then that just leads into a whole other thing. So,
yeah, Your Honor, I mean, I have an offer, but from what Mr. Romero is representing, apparently he doesn't want to resolve the case.
Judge, when I spoke to him, he's looking forward to having his day in court. He will come back to court. That's why he has a mailing address, but he just can't afford the bond. That's why I'm asking for the court to consider seeing him ROR or on pre-trial release, Judge.
well, all this argument about having an 83-year-old mother on Social Security doesn't make sense because he's on the beach sleeping. So it doesn't make, sir, you don't have to respond. I mean, I'll read the probable cause affidavit. It's not just, on November 13th, the two officers were conducting a property check on Northeast 30th Street and Atlantic Boulevard, made contact with Colleen Byers and David Beanie, who were sleeping on the beach. Both were sleeping on a sheet and used sand to make a castle to block the water from coming ashore while they slept. I woke them up, told them they cannot sleep on the beach, and they both stated they can sleep here. This is a state park. They were previously warned in the same area by these officers a few weeks ago, and Beanie stated that he recognized the officer and confirmed he was warned in the past about sleeping on the beach. And while in the vehicle, Beanie stated that the more we make him leave, the more he will return to the same location and that he will see us tomorrow. And so based on those allegations, I am going to leave the bond in place at this time.
Your Honor?
Yes.
And I know, and I'm not trying to beat a dead horse, I just, for record purposes, I want to advise the court also. He was just arrested October 23rd for public indecency. He was at the same location at the beach, showering in the nude.
All right, so he has bonds. Kevin Durlem on page 4.
That's a good point, Brian. I'll raise that. I'm sure I'll get the case, I'll raise it.
All right, Mr. Durlem, you're before the court, sir, on a municipal ordinance matter for a trespassing charge. Sir, this KPS was issued August 15th. Mr. Durlem, what do you want to do today?
I wanna, plead no contest and get out of here, please.
All right, is it a time served?
It is, Judge.
All right, Mr. Durlem, the offer from the city is time served. Do you wish to accept that, sir?
Yes,
All right, please raise your right hand. Do you swear or affirm to tell the truth?
yes, I do.
Okay, Mr. Durlem, you can put your hand down. And do you understand the offer, sir, that has been extended to you?
Yes, I know who he is.
No, the offer to resolve your case is time served. Do you understand that?
Yes.
All right. Is anyone forcing you to resolve your case?
No, I just want to get it over myself.
Are you under the influence of drugs or alcohol?
No, I just have a couple of beers once in a while.
Do you need any more time to speak with your attorney?
I think I'm okay.
All right. Have you ever been treated for mental or emotional illness?
No, Your Honor.
And do you understand, sir, that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
Yes.
What plea do you wish to enter at this time? Your options are guilty or no contest.
No contest.
All right, I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence, sir, is adjudication and time served. Mr. Durham, just don't drink in public, okay?
Okay, thank you. Thank you, Your Honor.
All right. Arthur Mitchell on page 5. All right, Mr. Mitchell. Mr. Mitchell, you have 2 misdemeanor cases on municipal ordinance violations.
Yes, ma'am.
Sleeping on the street and for solicitation. You didn't show up for court back in April 2 times.
But, Your Honor, I was at, I've been at Audemars Steps for 4 months now.
Okay.
I went to go, I didn't know that I had the charge, that the charge was open. So my judge took me to House of Hope, and I've been there 4 months there, and I went to go and get my teeth made, and the cop saw me and told me that I got a warrant for my arrest. I didn't know that though.
Okay. Well, now that you're here today, Mr. Mitchell, do you want to resolve your cases?
Yes, ma'am.
All right, I'll sentence you. The city is offering you adjudication time served. I'll accept that offer. Do you wish to accept that offer?
Yes, ma'am.
All right, Mr. Mitchell, if you can, please raise your right hand. Do you swear or affirm to tell the truth?
Yes, ma'am.
Okay, you can put your hand down. And Mr. Mitchell, do you understand everything we've discussed here today?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorney?
No, ma'am.
You understand that you have the right to go to trial, but by taking a plea today, you are giving up that right.
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
Yes, ma'am.
Is there anything about that illness today that would prevent you from making a decision?
No, ma'am.
And do you understand, Mr. Mitchell, that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
Yes, ma'am.
What plea do you wish to enter, Mr. Mitchell? Guilty or no contest?
No contest.
All right, I accept your no contest plea. I find that it's freely and voluntarily given, and your sentence serves adjudication and time served. Good luck, Mr. Mitchell.
Thank you.
You're welcome. We need the,
Our interpreter is present, Your Honor.
who needed the Creole
On
interpreter?
page 9, Mr. Chedler Sterling.
He's approaching, or me?
All right, Chedler Sterling. Mr. Interpreter, if you'll raise your right hands, do you swear or affirm to interpret from Creole to English and English to Creole?
Yes, I do. Bayardel, B-A-Y-A-R-D-E-L-L.
Thank you so much. Chedler Sterling, you're before the court today. Charge 1, driving while license suspended.
Je vous devant court là jeudi, où tu as conduit avec une licence qui était finie.
I'm sorry, was he already arraigned on these charges? Is he only here for the immigration hold?
Yeah, that's what I thought, because I don't have his paperwork. That's the
All right. Mr. Sterling was already, had first appearance on the driving while license suspended charge.
Te gen deja gon premi apérans parce que tu as conduit avec une licence qui pas de bon.
And he had a $100 bond on that charge.
Et ou gen on bon $100 pour charge ça.
And then he also has expired vehicle registration over 6 months.
Ou gen machine nou qui gon de registration qui fini depuis 6 mois.
But today, he's before the court for the add charge of an immigration hold.
Mais je dis ou gon l'autre charge de immigration.
It is a no bond hold by the Department of Homeland Security,
Pas gen bon, c'est Homeland Security qui mette le sous.
and so he will have to appear before an immigration judge on
Faut
this
paraître
charge.
devant un juge immigration pour bailler ça.
Okay?
All right.
Is there anyone else who needed the Creole interpreter?
Not here, Madam Judge.
All right, thank you,
All
Mr.
right, thank you,
Bayardo.
Judge.
You're welcome. All right, Frandy Colas on page 11,
Judge, you're gonna inform medical reset?
medical reset. All right, there's someone who signed in for Colas. Is that person here? She's not gonna appear before the court today. He's not coming today. They'll be reset for tomorrow. There's
I
some.
mean, I can ask you this tomorrow, Judge, but based on my conversations with his sister who's present, we are gonna be asking for a mental health screening.
Okay, so I can sign that order.
Okay, I'll draft that order now, and we'll have him here hopefully tomorrow morning.
Randy Colas, okay? On, all right. On page 2, Tanisha Edwards,
North Broward.
Medical reset?
all right, the same for Miss Edwards. If someone signed in on Miss Edwards,
I let them go earlier,
Oh, you
Judge, I
did?
told them, so they would.
okay. All right, on page 14, Nicholas Jones. Good morning, sir.
Judge is here present, and, at this time, after speaking with Mr. Jones, he declined the services of public defender, he's representing himself.
All right, Mr. Jones, you understand that you are entitled to counsel at this hearing?
Yes, sir.
All right, and so you are declining the services of the Public Defender's Office this morning?
See if any history.
Yes, sir.
You will be hiring a private attorney?
Yes, ma'am.
Okay. All right, you are before the court this morning. Charge 1 is extortion or threats. And then number 2, you have an immigration hold. It's a detainer. Well, I don't have any paperwork on the detainer. Is there a detainer for Mr. Jones? Mr. Jones is on page 14.
No, they don't give that to me.
All right, for the charge number 1, I find probable cause. I have no paperwork for the immigration hold. And so I'll hear from the parties at this time.
Trish, do you have any history on him? Your Honor, I'm going to be requesting a $10,000 bond, no victim contact. I do not know if there's any history or not. I will proceed as though there is no history. I know there's no history in Broward.
Okay?
I am concerned that, and based on his admissions, he went to this person's home, he threatened the person's life, his family's safety, made gestures to indicate that he had a firearm, brought other people to intimidate the victim, then taking the victim from the scene to get money from his ATM.
All right, sir, is there something you wanted to say?
Yes, Your Honor. My name is Javed Ishaq. I'm the uncle of Nicholas Jones. Nicholas works for this individual, and this individual did not pay him his 2 days' work. Nicholas went to his house to ask him for his money that he owed him for his 2 days' work on several
I'm gonna
times.
stop you. Were you
Right.
there? Were you there?
No, I know of the incident because,
Were you there?
no, Your Honor.
All right, so I think for you're the uncle. I think for his sake, then you probably need to have a conversation with his attorney, because everything you say can be used against you at a later time. as
Okay,
well.
well, the bond, I'm asking the court is to have, he doesn't work, no longer, and I am not working right
Up
now.
until when, because now you're saying he was working, up
Well,
until when was he working?
He was working for that individual 1 month ago,
Okay,
right? Nicholas does not get into trouble. He has never been into trouble. This is his first, and it's a threat. And, financially, we don't have no sort of money. Even putting him a bond of $1,000 is not something that I can afford right now.
he's facing a second-degree felony, all right? And the allegations are, and I don't know if he was owed money or not, but there are ways and there are ways. And so here, it says that he believed money was owed to him by the victim's uncle for work,
Correct.
and he was not paid. But he went to the house, demanded money, and then there's a statement that we will wet up, which means shoot up the place. And during the threat, the defendant's cousin made a gesture towards his waist that he was holding a firearm. The victim felt that the act was imminent, and so the victim was driven to an ATM machine where he removed money in cash and then was given to him. And that's why there is a charge of extortion, all right? And I know you're here today, you may not be here tomorrow or this afternoon, but there is also, as I'm being told by confinement, and this is just for your information, that there is also an immigration detainer warrant, which will have a no bond hold as well. That's coming. I don't have that this morning, but that's confinement informed me that that's coming as well. Okay? So at this time, I find probable cause and noting that he has no priors, but also noting the nature of the charge, I am going to impose a $2,500 bond at this time. No victim contact and no return to that location.
Your Honor, I strongly beg and ask the court to reduce that bond from $2,500 at least to $1,000 because I don't have that sort of money right now.
This time, sir, sorry. Okay,
Thank you.
all right. On page 10, Xavier Smith.
Judge, this year President of Maine, he declined the services of public defender, he's going to be representing himself.
All right, Mr. Smith, you understand that you are entitled to an attorney for this hearing?
Yes.
And are you refusing the services of the Public Defender's Office this morning?
Yes.
Okay. You are before the court this morning. Charge 1 is burglary, unoccupied conveyance, unarmed. Number 2, fraud, use or possessing ID of another person without consent. Number 3, petty theft. Number 4, criminal mischief. These are, the date of incident is from July 23rd of this year. And I find probable cause. Okay?
Your Honor, I'm looking up his history. I don't know, from the young lady, if you want to take some testimony from her. I don't know if she wanted to.
No, I'll hear from the state.
Okay.
Or were you asking for time to?
Yeah, I'm just looking up
Okay.
his history, so
All right.
rather
Good
than.
morning, ma'am.
Good morning, Your Honor. I'm his mother.
Okay,
The date that they stating that happened, my son died. I have the paper from his job.
All right, that is something that you will have to have a discussion with, well, he doesn't have an attorney, so that is something that you'll have to discuss with the state. Your son will have to have that discussion with the state, okay? Yes, sir.
On July 23rd, I was in Kennesaw, Georgia, when they accused me of doing this crime. Said I was on surveillance, and I was out of town. From Kennesaw, Georgia, I went to North Carolina with my job. I wasn't down in Florida. I was in Georgia.
That is something that will be, this is first appearance, so if you have evidence or something to present to show otherwise, that is something that will have to happen at another time, okay?
I even checked in the hotel. I opened a bank account up there. I wasn't in Florida to commit a crime.
All right, well,
Your Honor, first, well, I apologize. I don't know if you had more to tell the court.
No, I don't know if you wanted to see this paper.
We can talk about it after.
Okay.
Your Honor, I do see, as you can see on the booking, he was brought here from Dade. He was arrested in Dade on, I believe, the 9th or 10th for carrying a concealed firearm, grand theft firearm, possession of controlled substance, resisting without violence. Obviously, those charges are pending. Showing no other priors in Florida other than traffic matters. Your Honor, I'd be requesting a $2,000 bond on count one, no contact.
all right. Just so, I'll read the probable cause affidavit, so that Mr. Smith hears what it is that I had to review. It says on July 23rd, between 23:20 and 23:31 hours, a vehicle burglary happened in the parking lot of UFIT located at 10840 Pines Boulevard. The suspects used an unknown tool and smashed the driver's side window of victim's 2012 Nissan Altima. Once gaining entry, the suspects unlawfully removed victim's bag, which contained her debit cards and other items. Shortly after the burglary, victims started receiving alerts from her bank regarding fraudulent transactions from nearby locations. One of the transactions was at the 7-Eleven store in Miramar, 11150 Pembroke Road. The CCTV footage from the store showed the co-defendant Judon Roberson and defendant Xavier Robert Smith using victim's card and completing transaction for the amounts of $10.39 and $21.97. This was around 23:32 hours shortly after the burglary. A need to ID flyer was created and disseminated. My investigation developed Judon Roberson and Xavier Robert Smith as suspects in this case. And they reviewed the CCTV footage from the case and positively identified both Roberson and Smith from the video. Okay, so just the sequence of events described above showed a clear correlation between the vehicle burglary and the fraud that was committed thereafter. Right, so that's information that I have. I have to rely on the four corners of this paperwork to determine probable cause. Based on that, I have determined probable cause. All right. As to charge number 2, 1, I am going to impose a $2,000 bond, and he has a $1,000 bond on 2, a $100 bond on 3, and a $25 bond on 4. Okay?
Okay, ma'am, thank you.
Your Honor, just as an officer of the court, I have made a copy of the document that the young lady brought in. I'll be speaking to the ASA assigned to the case, and we will look into this matter.
So, okay, thank you.
Thank you so much, ma'am.
Okay. Alicia McLeod. All right, Ms. McLeod is before the court on a traffic KPS. And it's for an operating without a valid license. This is a capias from last December, 2018, and she has a $1,500 bond that was issued by Judge Hurley. So what,
Judge, my understanding is that her boyfriend is going to be posting her bond. Can we check to see if her bond's been posted?
okay? It's not showing yet, Mr. Romero. She has a $1,000 bond, okay? On page 14, there's a Carlton Reese. I'm sorry?
Reese is here present, Judge?
It's 1,500. All right,
Judge, Reese is here present. He declined the services of public defender. He's going to be representing himself, Judge.
all right, Mr. Reese, you understand that you are entitled to counsel for this hearing,
Yes, ma'am.
all right? And you are declining the services of the attorneys of the Public Defender's Office?
Yes, ma'am.
Are you going to represent yourself for this hearing?
Yes, ma'am.
All right. You are before the court this morning. There's one charge of criminal attempt to solicit, conspire, third-degree felony burglary. And I find probable cause. This is a third-degree felony charge, which carries a maximum sentence of up to 5 years in jail. Does Mr. Reese have any priors?
Does have a juvenile history that involves, from what I can see, 4 prior burglaries, all last year.
All right. Good morning, ma'am. Is there something you wanted to say? How are you related to Mr. Reese?
I'm his mother.
Okay.
I'm sorry. I apologize.
No, that's okay. Take your time.
I know he's have a bond set. I can't afford it. I just recently moved back into a home. We were evicted due to me having a major surgery, me being out of work for like 3 months or so. I don't know if his bond can be reduced. I don't know how to help in this situation or what the next steps would be.
Honor, I don't know if the court would be inclined to, or if I could, if you want me to inquire, if his mother, is Mr. Reese going to school? What does he do during the day?
Just waiting for her to.
Oh, I'm sorry, and I apologize. I just have a thought going through my mind that I was.
He was enrolled into school, but due to the fact of us having to move and being separated for a couple of months,
When did that happen?
August, July, the end of July,
Okay.
August, and we just moved in the home on actually Sunday. He was staying partially with a friend and with his girlfriend. I was living in Miami with my mom, doing the best that I can until we're able to find a roof over our head, which that happened.
Okay.
Not sure what provoked him or caused him to do what he did. But of course, I'm here to support him because he's my son. But right now, I just financially, I don't have it to bond him.
All right. All right, Mr. Reese, what's going through your head?
Hello?
What do you have to say in regards to being any release at this time? What do you have to say in regards to any release at this time?
What you mean? Like, can you explain?
Well, do you want to post a bond? Do you want to be on pretrial? You don't have an attorney, so you need to answer those questions. What is it that you want to do?
I would like to be on pretrial.
Has he ever been on pretrial before?
No, ma'am.
All right, and you said he has juvenile priors?
He does. He has at least four prior burglaries. He has a trespass as an adult. What's concerning about it is the trespass was he was a passenger in a stolen vehicle, and just with everything else. I don't have a problem with the pretrial with the GPS, and that's why I was asking if the court could inquire. If he's not working and he's not going to school, frankly, to ensure that there should be no issues of him even having the opportunity to go outside to commit any more burglaries, I'd ask that it be a level 1. If he wants to enroll in school or has some prospects for employment, then certainly whoever's representing him can go in front of his judge and seek a modification at that time.
All right. All right, and so he's going to be living with you?
Yes, ma'am.
All right. So you can provide the information. I'm going to release him to pretrial supervision, but he's going to be on a level 1 pretrial. That's pretty much house arrest. He's going to have an ankle monitor.
actually
He
what that
cannot
means.
leave the house.
Okay.
And if it comes up that he has to go to school or work or he gets a job, then that's something that can be readdressed before a division judge. Okay? All right, and ma'am, the pretrial officer will take the information from you right now, so if you'll just wait until she's ready, she can have a conversation with you to get all the necessary information. Okay?
Yes, ma'am. Thank you.
All right.
Thank you, ma'am.
You're welcome, sir. All right, do we have Joanne Marie Marsaro today?
I'm advised she refused, Your Honor.
All right, so we have had, it looks like 4 resets. And then today she's refusing, so today I am going to make a probable cause finding in absentia, and she needs to be brought back for bond, to set her bond. Destiny Barnes. Ms. Barnes is a medical reset. Ami Gridish.
Mr. Griffith, come on up, please. He's approaching Judge here, Maine.
Mr. Gridish is before the court this morning. There are 3 misdemeanor capuses. These were issued one July 22nd of this year on a battery charge. It did not show up for arraignment, and that judge issued a no bond hold. The other charge is also a capious August 1st for battery as well, and trespassing, and that judge also issued no bond holds. So I find probable cause, you'll have to see your division judge tomorrow at 8:30 a.m. David Cruz Osorio. Mr. Osorio is before the court on 2 misdemeanor capuses. Capious number 1 is for failure to register vehicle. There's a bond of $1,000. The second charge, unlawful license tag or sticker, you were ROR'd by the judge who issued the capious. So I find probable cause.
Judge, after speaking with Mr. Cruz, he wishes to resolve this matter today.
Okay,
Offers withhold court costs on both counts.
okay. Withhold adjudication means no conviction on your record, and you have to pay court costs. Do you wish to accept that, sir? All right. Mr. Osorio, if you'll just step in front of the mic, you can only have one conversation at a time, okay? All right. So the offer is a withhold adjudication and court costs. Do you wish to accept that?
Yes.
All right, please raise your right hand. Do you swear or affirm to tell the truth?
Yes, ma'am.
Okay, sir, you can put your hand down. And do you understand the offer that has been extended to you to resolve your case today?
Yes.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorney?
No.
You understand that you have the right to go to trial, but by taking a plea today, you are giving up that right.
Mm-hmm. Answer out loud. What do you mean? Yes or no? What do you mean?
Do you
You
understand?
don't
You understand?
understand? Just tell the judge I didn't understand. Can she repeat it again?
All right. All right. Can I tell you again that you need to focus? Okay?
Okay.
You have the right to go to trial. Do you understand that?
Uh-huh. Okay.
It's got to be yes or no. You either understand or you don't. You have the
No, I
right.
don't understand.
Okay.
Can you explain it? Like, I don't understand what...
Everybody.
Just pay attention to the judge, okay?
Everybody who gets arrested can go to trial. Do you understand that?
Okay. Yes.
And you have a charge that you could go to trial on. Do you understand that?
Mm-hmm.
It's got to be yes or no.
Yes.
All right. One more time, because I'm not sure if if you're just having an attitude or if you really don't want to do this. And if you don't want to do this, that's fine. I can leave your bond in place, okay?
That's what I want to do.
All right. So, by taking a plea today, you will not be going to trial. Do you understand that?
Okay. So long.
All right, we're done. Mr. Osorio has $1,000. He has $1,000 bond.
No, I know. You said that, but I'm asking for a phone order.
Okay.
So you can access his phone, post his bond.
Okay.
Thank you.
Jackie Denmark.
Just maybe just confirm it. I mean, it's kind of a moot issue. It can't be.
He's your president.
Mr. Denmark, you're before the court on a KPS that was issued February 5 of 2018. The charge is operating without a valid license, and the KPS was issued because you didn't show up for court. All right, I find probable cause.
His EOS date is this Monday. He was serving a state sentence.
Okay.
I asked Mr. Denmark if he wishes to resolve this or Friday. He wants to resolve it, so we're asking the state if they have a plea offer.
Okay.
One moment, Your Honor. Offer is time served.
All right.
He wishes to accept the state's offer, Judge.
All right, Mr. Denmark, please raise your right hand. Do you swear or affirm to tell the truth?
Yes, ma'am.
Okay, sir, you can put your hand down. And do you understand the offer that has been extended to you, sir?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak with your attorney?
No, ma'am.
You understand that you have the right to go to trial, but by taking a plea today, you are giving up that right.
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
No, ma'am.
And do you understand, sir, that if you are not a U.S. citizen, that by taking a plea today it could subject you to deportation or immigration changes?
Yes, ma'am.
What plea do you wish to enter, Mr. Denmark? Guilty or no contest?
No contest.
All right, I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence serves adjudication and time served. Benjamin Felipe,
He bonded, Judge?
Mr. Felipe bonded. I find probable cause. Jesse Wilson.
Mr. Wilson, come on up, please. How you doing, Judge?
I'm well, Mr. Wilson. Mr. Wilson is charged with touch or strike battery, and I find probable cause.
Judge, I'm going to be asking for the court to consider releasing him ROR My understanding, he works off and on landscaping, been here his whole entire life. He lives in Palmetto Beach with his 98-year-old mother. She is on Social Security and she cannot afford posted bond, so we're asking for the court to consider releasing him ROR on this misdemeanor offense, Judge.
All right, I know, Mr. Romero, you've not seen the probable cause affidavit, but here it says that Mr. Wilson unlawfully struck the victim on the left side of her face with an open hand against her will. The defendant is not known to the victim. And so it appears some random violence for no reason, if that's how I interpret this probable cause affidavit.
Judge, Mr. Wilson wants to talk about the facts. I told him not to. He'll have his day, but there is more to this story, Judge.
The court should also be aware that Mr. Wilson pled out 2 separate VOPs for felony battery due to prior convictions. He was arrested in November of last year. He was sentenced to 180 days county jail and was released March of this year. And I'm showing before Judge Siegel on a charge of aggravated battery, great bodily harm. He just pled to the charge October 16th for a time
This year?
served off, yes, for a time served offer of 296 days.
Okay. Well, I'm gonna leave his bond at $1,000 at this time, okay? Emmanuel Ocelin,
Come on up, sir. Come on up, Mr. Olson.
Mr. Ocelin, you're before the court. Charge 1 is DUI, alcohol or drugs. Number 2 is DUI with damage to property or person, and number 3 is careless driving, and I find probable cause for these charges.
Judge, I'm going to see if the state has an objection to this. I'm just going to be asking for an ROR on count 1 so he can self-bond. This is the first time he's ever been arrested in his life. He's working, he lives in Tamarack, but he has no one to contact to post his bond, so he's going to post his own bond, Judge.
I don't have an objection.
So ROR on count 1, and he has a $1,000 bond on 2, okay?
We're just
Eduardo,
on a property order, Judge?
yes.
Thank you.
Eduardo Gonzalez.
Yes.
Mr. Gonzalez, you're before the court because there's an immigration hold that has been added to your charges. The immigration hold is a no bond hold, and I find probable cause based on the paperwork that's been provided by Department of Homeland Security, and you will have to appear before before an immigration judge on this charge, okay?
Okay.
All right. Gary Altman.
Conti again, Your Honor.
Mr. Altman, you're before the court on an ad charge. This is now charge number 3, and this is for grand theft. And the theft is for the GPS equipment, okay? So,
Mr.
I don't
Alderman,
have it.
right. You don't have the GPS equipment and they can't find it because they're saying that you cut it off.
Don't say anything about the facts of your
he's
case,
being
sir.
held no bond on a separate.
All right,
I'd
so
ask you to leave the bonds in.
is
Cut it
it,
off at the jail.
Don't talk about this is not the time to confess.
you have a $1,000 bond, sir. All right, Robert Walker.
No problem.
Good morning, Judge.
Good morning, Mr. Walker. Mr. Walker, you're before the court for 2 additional charges. Number 7 is burglary, unoccupied structure, unarmed. And number 8 is committing a grand theft with property damage. And these incidents are from December of last year. To the Rent-A-Center, to Precision Repair and Overall to Shots Liquor Store. So these all are all incidents from last December. All right, I find probable cause.
Your Honor had set his bond on his other burglaries at 5,000 each. They're all of the, pretty much, as mentioned in the report, the same nature, using the car as an instrument to gain access to the businesses.
Yeah, but I'm not charged with this burglary of using the instrument. So let's clarify that. Stop trying to classify this charge as being the same as ones before. The ones before I was charged with using the instrument. This charge is so strictly burglary of a structure.
All right, Mr. Walker, did you hear what I read?
Yes, ma'am.
Okay, so you have a $5,000 bond on charge number 7, and on number 8, you have a $7,500 bond. Okay? All right, Gerald Zafuto.
I'll call your mom, Robert.
And my understanding, he has private counsel, Mr.
He does.
Edward.
He does. He was here yesterday. Are these additional charges?
Yes, Your Honor, these are separate and apart from the two cases that were before you yesterday.
Who was his attorney again? Mr. Who?
Mr. Cilantro.
Mrs. Cilantro.
I don't know if Mr. Reedy might have, I don't know if he reached out or not this morning.
Mr. Reedy, did you talk to Mr. Cilantro this morning on Mr. Zafuto?
I haven't, Judge. I was going to call him. I just really haven't had a chance. I think when he was here yesterday, he indicated that he's still trying to work out an arrangement with Mr. Zafuto to represent him on these new cases.
That's true.
I do know that he is being held no bond on other charges. So
was
I'd
on-
ask the court to, I'm not going to stipulate to.
No, so Mr.
Zafuto.
Zafuto, yesterday when Mr. Cilantro was here, he said he was only retained on one, well, he did come as a courtesy.
Yes, ma'am.
I don't know.
He still only represented me on one case.
I'll reach out if you like.
Yeah, let's see if we can call him and just let him know that there are 2 more cases if he wants to be here, please. And so we'll recall you, Mr. Zafuto, okay? Roberto Torres Sarmiento.
Oh, I don't know. I didn't pay attention. I'm sorry. Judge, the last gentleman.
We're recalling him. We're gonna call his attorney. Mr. Sarmiento is before the court. Charge 1 is violation of felony probation, and that has a no bond hold on the warrant that was signed by Judge Yuson. And then there's an immigration hold, and that also is a no bond hold by the Department of Homeland Security. I find probable cause, and Mr. Sarmiento will be before Judge Yuson tomorrow at 8:30 a.m. Jason Morse.
Some more. North Broward, Judge.
Sheila, this is the one.
All right, so on this one, Mr. Morse was remanded, he was removed, okay. All right, Romero Medward. All right, Mr. Medward is before the court. Charge 1 is burglary, occupied dwelling unarmed. Number 2 is petty theft. And number 3 is wearing a mask while committing a second-degree misdemeanor.
I think this is a structure, Your Honor.
Burglary of a, let's see,
It specifically refers to an ace.
this is not a business, not open to, okay. So burglary of a structure is the charge. All right, I find probable cause.
Judge, I'm going to be requesting that the court consider setting a $1,000 bond on count 1. Mr. Medward, he's 27 years old, been living in our community for the past 10 years. Right now, he's not working. He was previously working for an air conditioning company. He was making good money, about $1,800 a month. But unfortunately, he's let go, and now he's currently looking for employment. He lives with his mother. She's a caretaker. She supports him as well as his younger sibling. So, Judge, his financial resources are limited. So that is why we're asking on this offense a $1,000 bond on Mr. Modar's behalf.
Your Honor, I'm going to be requesting a $3,500 bond. I guess Mr. Romero's not aware of this. I know the court is. We really didn't need to be told where he used to work because the allegation is he broke into his former employer's business.
And he has priors?
He had a felony drug possession earlier this year that he pled out to a paraphernalia.
All right, he has a $2,500 bond on charge number 1. Okay.
Ask for no return, Your Honor.
And no return to this location.
Mr. Solantri is on his way, Judge.
All right. Israel Desmangles.
He refused.
All right. So we'll reset Mr. Desmangles. Carlos Robinson.
Mr. Robinson is here. Angel, come on up, sir.
Mr. Robinson is before the court. Charge 1 is robbery firearm. Number 2 is attempted felony murder. Attempted murder in the first degree.
Yes, Judge.
I find probable cause.
Sheila, was he brought down here by a transport order? Your Honor, I'm going to be asking that the court make a finding of proof evident or presumption grade for first appearance purposes based on the probable cause affidavit that's been provided. This is a filed case. Should the court make a finding of proof evident or presumption grade, I'm going to ask that the court not exercise discretion in setting a bond. He currently has the Department of Corrections hold. He was transported here from Franklin Correctional Institute. I believe Judge Siegel signed the transport order, I believe.
Okay.
Would object. He has a state sentence. Is that what you said, Mr. Linder?
He's sentenced to 4 years on October 31st, 2017.
All right. Would object that the state has not met that burden, Judge, and ask you to set bond for Mr. Robinson.
So based on the allegations, there are fingerprints that were taken from the vehicle. There was connections of phone calls between the phone number that was pinged from the cell tower during the time of the shooting, at the shooting location. Based on those allegations this morning, I find probable cause. I am going to make a further preliminary finding of proof evident presumption grade. This is without prejudice for Mr. Robinson to have a bond hearing before his division judge, and until such time he will be held no bond. Ellis Ladson.
Mr. Lasson, come on up, please. He's approaching, Judge.
Good morning.
Good morning, Mr. Ladson. You're before the court. Charge 1 is petty theft. Number 2 is possession of methamphetamine. Number 3 is possession of clonazepam. Number 4 is possession of drug paraphernalia. Number 5 is possession of cocaine. I find probable cause for these charges. And does anyone wish to be heard?
Yes, Judge. Mr. Lasson's 39 years old. He's been living in Florida his whole life. Right now, financially, he can't afford to post his bond, nor his family. Unfortunately, he suffered a loss. His brother passed away November 9th, and his family spent basically everything they had arranging for his funeral, which was held, I believe, November 12th, about 2 days ago. Right now, he's not working, Mr. Lasson, and nobody can help post his monetary bond, so that's why I'm asking you on these nonviolent offenses for the court to consider releasing on pretrial, and I know they're drug offenses, so also we want to object that the court wanted to go ahead and impose random drug testing for Mr. Ladson. Yeah. None.
I will say that I've struggled with drug problem, but my brother died, and it was just I couldn't
Don't talk about that.
I couldn't cope, so couldn't cope. I needed something to cope.
Mike, Your Honor, one of my concerns is it would appear he's got two separate warrants out of Palm Beach County for failing to appear in court last September, on two separate trespass cases.
Those warrants are still outstanding?
Yes, they may be Palm Beach County arrest only. I'm just checking because I'm getting hits out of Ohio, Missouri, and California.
At this time, I am going to leave the bonds in place. You know, these allegations began in reference to shoplifting. And then when the bag that was found had some of the items in there, and then he was searched, and then there was a secondary search, and then when he got to the jail, there was another search. And each search, there were different drugs that were found. So I am going to leave the bonds in place at this time. If Mr. Ladson wants to enroll in the SAP program, I'll be happy to sign an order in regards to that.
What would the SAP program be? Is it for drugs?
It's a substance abuse program.
And how would that help me with my problem?
I don't know. I can't tell you
Um,
that.
I think it would.
Okay, well, can I sign up for it?
Judge, would you sign an order recommending he be placed
Sure.
in the SAP program?
I will.
Thank you.
You're welcome. Sean Shire?
Please approach the judge.
All right, Mr. Shire is before the court. It's an attempt.
Basically, what the officer did was he charged him with the burglary statute and the attempt statute. It should just be treated as one count of attempted burglary. I have no objection to an ROR on count two.
All right, so, Mr. Shire, it's an attempted burglary on charge 1. And I'm find probable cause on that. And then on number 2, I'll, no probable cause on that one. And ROR you on that charge. All right, so,
Judge, Mr. Shirley advised me he's had prior contact with the criminal justice system, but his most recent, I believe, was non-violent. I believe it was a misdemeanor offense. He's been here almost half of his life. He was supposed to just start employment at Pace Setters. Financially, he's indigent. He's homeless. He does have a mailing address where he gets court notices, but he's asking to be released on pretrial.
I just got a job that starts tomorrow.
all right, State, does he have any priors?
One moment. Get a robbery that was declined late August of this year, trespass from May of this year, loitering and prowling from May of this year, tampering with evidence 2018, paraphernalia 2018, theft 2018, theft 2018, loitering and prowling 2018, dealing in stolen property and grand theft 2012, burglary structure and 2 burglary conveyances 07.
Charge one, then yes, I am going to impose a $2,500 bond and no return to that location. Windsor Remy,
Mr. Remy is approaching the hearing main judge. Judge, he declined the services of public defender. He's going to be representing himself.
Your Honor, may I approach before the court makes any determinations?
okay.
I provided a supplement or perfected version of the PC affidavit, which mentions that the drugs were field tested.
All right, Mr. Remy, you understand that you are entitled to an attorney for this hearing?
Yes, ma'am.
And are you declining the services of the Public Defender's Office this morning?
Yes, ma'am.
You will be representing yourself for this hearing. Is that correct?
Yes, ma'am. Yes, ma'am.
All right, you are before the court this morning on one charge of distributing or delivering heroin, and I find probable cause for that charge.
Your Honor, the defendant was
Yes,
placed on
ma'am.
pretrial supervision on the 25th of September for possession of heroin. The case number was 19-11695 CF10A. Based on this court's finding of probable cause, we're going to ask that his pretrial status be revoked in that old case.
Okay. All right, and so, Mr. Remy, just in case you didn't hear, pretrial supervision has just advised me that you were placed on pretrial supervision September 25th of this year on a similar, well, it's a possession of heroin charge, and they're asking that your pretrial be revoked. Does what other priors does he have?
One moment, Judge. Other than the case before the court and the pretrial case, possession of cannabis in 2010 and 06.
Okay. All right. Mr. Remy, at this time, I am going to grant pretrial's request to revoke your pretrial, and I am going to impose a $2,500 bond on case number 19-011695 CF10A. And in this case, you also have another $2,500 bond, okay? All right, sir. Alan Mauk.
I'll wait.
All right, so Mr. Mauk is, I'm sorry?
One moment, Judge.
right, I find probable cause on the charges presented.
And Your Honor, I'm going to be asking either if the court can find PC and leave them in no bond or even take no action. My understanding, I spoke to a confinement. Both these counts, Your Honor, it's the same case. One arrest was made on the arrest warrant. The other is on the court order from Judge Lynch on the file charge. And he is set to see Judge Lynch on, do you have that? No, Sheila? Yes, on the 18th, Your Honor.
Okay,
So,
all right, so Mr. Malk was returned to face these charges. These are, this is an old incident date from December 20th of 1998. And based on DNA evidence, this charge has been presented. Has the information been filed?
yes, Your Honor.
Okay, all right. And so I'll leave everything with a no bond hold at this time. Jesse Melgoza.
Please approach the judge.
Mr. Melgoza is before the court on a violation of parole charge, and that is it has a no bond hold, and Mr. Melgoza will have to go before the parole board on this charge. Malik Wright.
Mr. Wright, come on up, please.
All right, so Mr. Wright has a criminal attempt to solicit, conspire, third-degree felony burglary, and then he has charges 2, 3, and 4, which are court orders with no bond holds. Those are not for magistrate, so I find probable cause. He has a $3,500 bond on one, and he will have to see his division judge on the other matters. Okay. Julius Lawrence.
Please approach the judge here with me.
Mr. Lawrence is before the court, one charge of aggravated assault with a deadly weapon without intent to kill. And number 2 is a touch or strike battery. And I find probable cause.
Judge, my understanding is being Mr. Lawrence, he's 45 years old. He works self-employed as a welder. He's been doing that for 10 years now. My understanding, he lives in Fort Lauderdale. He's been residing in the same apartment now for about 6 months, paying about $550 per month. From what he advised me, he has a prior contract with the criminal justice system, but it's been many years. My understanding is there's probably more to this story. I believe the alleged victim is a lifelong friend, and I believe this may have happened about 2 or 3 days ago, and I believe since then, don't think like that. My understanding is he's probably going to go to the state attorney's office in the future and try and sign a waiver of prosecution. Having said that, I did advise Mr. Lawrence, most likely the court's going to impose no sort of contact order. He will be abiding by that. But we're asking at this time, Judge, for the court to consider setting a $2,000 bond on that one.
First, Your Honor, first thing I would note, and I would ask the only thing the court should take into consideration as far as the future of this case is it documented in the sworn report that the victim advised he does want to press charges. As far as his history, I don't know how one defines many years, but in 2014, he was convicted on federal charges of felon in possession of a firearm. He was sentenced to 16 months in federal prison to be followed by 3 years supervised release. I see an arrest in 2017 in Alabama for assault with bodily fluid. I have no disposition on that matter. He was picked up in 2012 in Alabama for failing to appear in court. Assault against a law enforcement officer, 2010. Failure to appear. He's actually charged with failure to appear on a domestic violence case, and he was convicted of that in 2010. another failure to appear in '09, assault in '09, obstruction '09, assault domestic violence '01. So it would certainly seem there's multiple prior instances of him assaulting people and at least one of unlawfully possessing a firearm. Your Honor, I'd be requesting a $7,500 bond and no victim contact.
$5,000 bond on one, $1,000 bond on two, no victim contact. That means no phone calls, no text messages, no social media, no third-party contact. Do you understand that, sir?
Yes, ma'am.
All right. Mr. Cilantro, you ready?
Yes, ma'am.
Gerald Safuto,
He's approaching, Judge.
thank you.
Oh, Jerry?
All right, 2 days in a row, Mr. Cilantro.
Yes, Judge, my pleasure. Good morning. Thank you, Mr. Reedy.
There are two more charges, another burglary and a grand theft.
Judge, I just was provided a copy of the PC. I scanned over it. The only thing I'd point out there is that, I don't know what the bonds are. I can't tell from the paperwork I looked at.
Well, one is a first, it's pretty much the same, it's a first-degree felony,
It's a PBL again, Your Honor,
punishable by life, and
So it's a burglary structure unoccupied.
with damage over $1,000.
damage, yeah,
That's what's charged.
yeah.
I don't represent I didn't even know about this case. It's
I know.
totally new to me. I'm just here as courtesy.
And the only reason why I called is because you were here yesterday. I know that you did represent, you were only retained on one case.
Right.
But I didn't, I didn't want to take
I'm
a
more than
chance
happy
if
to
you
be
were
here.
going to be here, if
And-
you wanted to be here.
For purpose of this hearing, I will be happy
Okay.
to represent him on this matter.
All right,
He already has the two no bonds, I believe.
yeah.
At this point, we need to get these cases consolidated and figured on.
Right. Yeah, in these I don't know if you saw the probable cause affidavit, but this one is that, it looks like, well,
I did see it, Judge.
Oh, okay.
Yes,
All right.
and it's some unknown person identified as surveillance. I don't know how strong that really is in all frankness, but there is evidently a fingerprint. I don't know how they did that so quickly, but that's what the PC appears to be.
Yes.
I don't know who this Marnie individual is, where they found her, what their relationship is. So I think it's questionable, but I'll leave that to the
well,
court.
if you're retained, I guess you will make all those arguments at the right time.
Exactly.
I would know, I mean, according to her, she's known him for almost 30 years. So.
Okay. All right, so as to charge number 7, I am going to make the proof evident presumption great finding without prejudice, of course. He can have a bond hearing based on state v. author before his division judge. And then he has a $1,000 bond on number 8. I'll leave that in place.
No bond on the
On 7, I keep saying.
1,000.
Okay,
Okay.
all right, thank you.
You're welcome, Judge, thank you. Yeah.
Borsico Philemon.
He's here, main judge.
And Mr. Philemon is before the court. Charge 1 is driving while license suspended. Third or subsequent offense. And number 2 is a traffic infraction not for magistrate. I find probable cause.
Judge, at this time, nothing to add from the defense. I'm gonna be contacting his girlfriend and post his monetary bond.
All right, $750 bond. Michael Jobert.
Judge, I've been advised he bonded.
Okay. I find probable cause. Kevin Garajo.
Mr. Garajo, come on up, please.
All right, so, we did find probable cause on this charge, I think yesterday. He's reset for bond purposes, so I'll hear from the parties at this time. Mr. Garaja's charges are aggravated assault with a deadly weapon without intent to kill.
Judge, according to my, and I don't know, my docket is incorrect, does he currently have a bond right now of 2,500?
Not that I have.
Okay, then my docket's incorrect.
What might have happened is it written at 2,500 written on the findings anywhere, Judge?
Nope.
Okay, never mind. Patrice, do you have any notes on him? I don't know if there's any information Mr. Romero wants to provide. I need a minute to check to see if there's any history.
Judge, he's 21 years old. He's been here his whole life. He works in construction. Gets paid about $140 a day. He lives in Deerfield with his mother. They rent, they do not own. She's a house cleaner. My understanding is Mr. Garajo, he's been hospitalized now for a couple days. We're going to be asking for the court to sign a photo order so we can photograph the injuries he sustained. Right now, Mr. Garajo, he's not in a position to post his monetary bond. However, he's purely going to be relying on his mother to help post his monetary bond, but he doesn't know her financial resources. My understanding, he has prior contact, but I believe it's been about 2 years. That's all the information I have at this time, Judge.
Okay.
Not showing anything as an adult judge. Based on the level of violence, I'd be requesting a $2,500 bond, no victim contact.
Okay. Right, $2,500 bond, no victim contact. Stinfield Filsmagre. Smager.
He's here, present, Judge.
All right, I believe he was in court yesterday he was arraigned on this charge. And so this is a change of charge. Actually, it says it originally was attempted felony murder with injury, and now it's changed to attempted first-degree murder.
Yes, Your Honor.
What were
Actually,
the-
I'm sorry, no, it was for attempted second-degree murder.
Okay.
The first time.
Okay.
At his first appearance. Now it's been upfiled. If I could just have a moment, please. Just trying to pull the original findings. Your Honor, bond was originally set at $50,000. No victim contact, no weapons. Because it's been upfiled to attempted murder first degree, the only request I'm going to make is, in addition to the $50,000 bond that was previously set, that he be placed on, if he posts bond, that he be placed on a GPS monitor, level 2.
By the PD, Mr. Romero?
He is.
Judge, as you heard, he did have a $50,000. He didn't post it because financially, him nor his wife or his mother, no one can afford to post a bond. So he.
And what kind of priors does he have, Mr. Linder?
He pled, 2017, he pled down a felony offense to a misdemeanor battery with a resisting without violence, and he went through diversion on an unlawful use of false name in 2016.
Can I see the paperwork from the original affidavit, just the affidavit?
Yeah, I'll print out the warrant affidavit.
Okay.
Actually, forget about that. No, it just isn't everything. So,
Thank you. All right, based on these allegations that I've reviewed again, I will grant the state's request to add the pretrial level 2. No victim contacts remain in place and no weapons or firearms. Eric Russell? Thank you. And Mr. Russell, this is an add charge. This is now charge number 4. There's also a change of charge?
The aggravated battery, it was changed from one type of aggravated battery. Hey, guys, wait, just wait. One kind of aggravated battery to another kind, from deadly weapon to great bodily harm.
Okay. So I guess they wrote it on and then they crossed it out. So the other,
It's an odyssey.
so there should be a possession of weapon or ammo by a convicted Florida felon,
It's a war.
and then an aggravated battery. No, so what are the charges then? On the KPS, I have aggravated battery with a deadly weapon, and number 2, carrying a concealed weapon.
Yeah, and that's the charge number 4, which is the ad charge.
Okay,
Charge 1 is a change of charge. He was arrested for one type of aggravated battery. We filed it as a different subsection of aggravated battery.
so aggravated battery with a deadly weapon is what's been filed?
Yes, Your Honor, and bond was originally set at 5,000.
Okay.
One moment. He's got, on count 3, he's got a $100 bond on a paraphernalia. I was gonna be requesting a $2,500 bond on the firearm offense. Let me see what you got there. There's better stuff.
All right.
There's better stuff I can.
So just so you understand, Mr. Russell, I asked these questions so you can hear it out loud. They've just changed the battery charge that was the type of battery charge has been changed. So, but you still have a battery charge. So I'm gonna leave the $5,000 bond in place, and then they've added another charge, possession of a weapon or ammo by a convicted Florida felon. And on that charge, I also find probable cause, I am going to impose a $2,500 bond, okay? All right, Tyler Carson. All right, so Mr. Carson is before the court for a violation of probation. It's a felony matter. And so, Mr. Carson, we'll go see his division judge on this violation. There's a no bond hold until such time. All right, Michael Whitehead.
North Broward?
Mr. Whitehead is a medical reset.
Your Honor?
Yes.
If possible, if we could address it only because, and I don't know that he's gonna bond out, but right now, these are all change of charges. And right now, if it's not addressed, there are no bond holds for magistrates. It would just seem to me, at least having the ability to post bond on change of charges is better than having no ability to.
Well, did he have bonds in place before the charges were changed?
I imagine, yeah, it doesn't appear that they were changed from any punishable by life offenses.
Okay,
And that's why I was gonna pull the,
so okay.
it-
On my determination, form I have 8 charges, but looks like the KPS goes up to charge 11.
that is true, Judge. I just noticed that, and, one moment. Yeah, we don't have the. Sheila, do you know how this happened, that we don't have the ad counts booked?
It's, let's reset it.
No, I didn't realize that, so yeah, of
Okay,
course.
all right. Antonio Parison.
Who's the person, Judge, ma'am?
All right, so Mr. Parison has 1 change of charge to resisting officer with violence. How much bond did he have before? So I'll leave the $5,000 bond in place.
Guys, and just so Mr. Parison knows, I don't know if this is in the paperwork and the docket, he's scheduled for arraignment. His arraignment was reset and he's scheduled before Judge Fine, November 20th.
Gregory Wilson. Mr. Wilson is in court.
Brian, I don't know if, I'm checking to see
It's
if
another
he's,
change of charge.
yeah, and I'm checking to see if he's in court on this case. Fine with resetting it, Your Honor.
All right.
The only thing I need to know,
Maurice Lane.
Please approach the judge. Name. Come on up, sir.
All right, so Mr. Lane is before the court. I guess these two felony cases, was not supposed to be there? It's
I think
crossed
he might
out.
have already had his first appearance on those
Okay.
two.
So trafficking in heroin, 28 grams, less than 30 kilos. 4, trafficking in PVP, MDMA. Number 5, possessing a structure or conveyance known for drug trafficking. Number 6, possession of cannabis 20 grams or less. Number 7, possession with intent to sell, manufacture, or deliver alprazolam. And number 8, possession of fentanyl. Number 9, possession of drug paraphernalia. No. What is number 9? That is it really drug paraphernalia?
It should, one moment, let me see what they say. It should just be
It
possession
looks
of
like
drug
there's
paraphernalia.
a mixture of
I think it got
names.
accidentally booked as manufacturing and delivering when it should just be possession, so I have no objection to an ROR on that count.
All right. So we'll ROR on number 9. All right, I find probable cause.
Your Honor, I'm gonna ask that the court keep the bonds in place in light of the fact that on counts 1 and 2, he's being held no bond. He failed to appear at his arraignment before Judge Colra on October 25th for charges of burglary of a dwelling and possession of utilone. I believe these cases are assigned to Judge Colra as well, so he's gonna have to appear before Judge Colra to get any type of bond in the other matter anyways.
And judge, based on what Mr. Lender just stated, nothing to add by the defense.
All right, so I'll leave the standard bonds in place at this time. All right. All right. All right, thank you, everyone. Sign whatever else needs to be signed. There's always one more.